yes, to echo your disclaimer, which you so sagely gave out, before we get rolling today, again, I'm Evian White De Leon, Chief Legal Counsel for the Miami Association of Realtors, and we are thrilled to host this today, as well as all the other legal education that we host for our members, with the caveat that this is not legal advice. This is not legal representation. You should not rely on this as legal advice or representation. You should seek legal counsel from your own attorneys or the legal Florida Realtors legal hotline for advice specific to your unique circumstances. That said, some other housekeeping as we go along. We are recording today. We are recording the audio and video. So this will be available on Miami Realtors Live after today. Give us a little time to get it up, trimmed and up and running, but it will be on Miami Realtors Live. We are going to share the link to the slides, both now and after the fact. We will post the link to the slides in the chat as we go along for those who join us later in the program. But yes, the slides will be posted. And without further ado, we will jump into what we are going to chat about today. This is going to be a broad coverage of what's going on right now in the real estate industry and the hot legal topics that you need to know to mitigate risk and to make your business the best that it can be. And I certainly do not do this alone. I am humbled to work alongside and have the privilege of working alongside our wonderful Miami Realtors team. Some of them are on this webinar today. And if you have not met our legal and advocacy teams, they are up on the screen in front of you. Together, individually, we all have separate roles, but together we join forces to be the advocacy team at Miami Realtors. So wanted you to know that our advocacy team is growing in response to the needs of our members, the needs of what is going on in the real estate industry right now. Again, feel free to reach out to us at any point at advocacy@miamire.com if you have any questions in that area. Without it wouldn't be a legal update if we didn't cover the antitrust policy before we got rolling into some of the legal topics. So we are happy to do Q&A at the end. We will do Q&A after I give you sort of the state of the real estate union of what's happening right now. But I want you to know that Miami Realtors has an antitrust policy and we adhere to it. It is up on the screen. And I am not just going to rely on I'm not going to rely on just what's on the screen. I am actually going to take the time to read it to you today because it is that important given what the real estate industry is facing. So Miami Realtors adheres to a strict policy of compliance with both federal and state antitrust laws. As such, any discussions or activities with potential antitrust implications, including but not limited to commission price fixing, market allocation, customer allocation, bid rigging, or boycotts are strictly prohibited. Miami Realtors strongly endorses a competitive marketplace, ensuring that competitors have the freedom to engage in business without artificial restrictions on competition. So what does that translate to today? We are not going to discuss commissions. We never discuss commissions. So when you are placing your questions in the chat, do not ever, 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 ever put questions about percentages or anything along those lines, and for good reason, because if you do that, you are in a room full of competitors and you are now, you could now be accused of price fixing. And if you're sitting there thinking, I would never do that, I would never be silly enough to do that, well, congratulations, because you are a co-conspirator if you are in the room with folks who are having those discussions, even if it's on chat. So don't do it. If anything like that does come up in the chat, we will promptly delete it and we will promptly address it. All right. So on the antitrust note, what in the world is going on in antitrust litigation these days? I know that you all know that the antitrust conversation really came to a boiling point last October, actually on Halloween, when the jury verdict came down in the Sitzer-Burnett case to the tune of $1.78 billion, which could later balloon to $5 billion if the judge imposes statutory damages, which are allowed in antitrust cases. So what happened? What do we do now? And what can you do specifically to make sure that your businesses are protected? So First thing I'm going to say is make sure you bookmark miamirealtors.com/antitrust. That is where all of the most recent updates are going to live, and the resources will be for you. Everything that I talk about today is going to be on miamirealtors.com/antitrust. So what happened? We're not going to talk about in depth what happened. There's tons you can read. We've covered this in past webinars about what happened in the Sitzer Burnett case. The end of the story is a jury found that NAR and brokerages violated antitrust laws. And because they found that they violated antitrust laws, those damages were awarded. So it's really important to remember that there is no new law that has come out of this. So we've heard a lot about, well, oh gosh, will the industry going to change? There's all these articles, right, about what the industry will look like, what the DOJ is going to do or not do. Take a deep breath, because right now the law is no different than it was before October 31st. It is no different. Antitrust law is the same antitrust law that it's been, that you have to comply with and continue complying with. So how do you make sure you're doing that? Well, number one, get yourself an antitrust checkup. Just like you get your health and wellness checkups every year, you are going to want an antitrust health and wellness checkup. It is a lot less fun than your annual physical, but it is well worth it. What do you need to do? First thing you should do, if you have not done it already, is have an antitrust policy. And if you are wondering where you get that, miamirealtors.com/antitrust. You are free to copy and paste and plagiarize at your heart's content the Miami Association of Realtors antitrust policy. Adopt it ASAP. Put it in writing. Put your own companies in there. If you're an agent, doesn't matter. You can do it for yourself as the human, or if you are an agent with a PA or something like that, or an LLC working for a brokerage, do it. Do it, do it, do it. And if you are an agent, make sure your broker has one as well. That is, bare minimum that you can do right now. Not good enough to have that, though. You have to actually comply with your antitrust policy, right? So what else can you do? Lots you can do. So first thing is get all of your forms, your training materials, your forms, your contracts, get them to your attorney. You will need to go to your own attorney to get that checkup to make sure that there is nothing in there that is violating antitrust law. If you're wondering how the damages got to be so big in Sitzer Burnett, well, there was evidence that was presented throughout the trial, and some of the evidence included training manuals, things that were on social media that were posted, videos that were posted. All of these things came into play in the case, and there are more cases pending, and I'm sure that evidence will be there too. So you need to look at all of that stuff: training materials, scripts, your email templates, your independent contractor agreements, all of these things you need to take a good, close look at to make sure that there are no little lurking time bombs in there. You really need to do that. Last but not least, get education, right? We have Letty Oliver with us today as well on the Zoom. She is your Chief of Innovative Education, and she has put together more than I can count now, classes on ABR accreditation, which is the Accredited Buyer's Rep course. It's an NAR designation that you can get. She's put together the Florida Realtors licensed content on how to work as a buyer's rep. We've done independent so you've got the NAR perspective, the Florida Realtors perspective, and then we've done a ton of trainings like this one in more detail about what you can do to protect your business ASAP. Make sure you do that. Get that stuff, and once you have that education, once you have those accreditations, make sure that, again, you are taking your forms to your attorney to get them looked at. That includes your buyer's rep form. If you're thinking, well, Florida Realtors has one on their website, I'll just use that one. Take that to your attorney as well, because you want to make sure that you have specific legal advice to your brokerage, to your practice, that you are getting assessed. There are unilateral and independent business decisions that need to be made about quite a few of those terms in there that you and your attorney can work together to change. Don't do it yourself. You don't want to, Article 13 Code of Ethics violation on your hands. But if you go to an attorney and work together to make sure that your unilateral and independent business decisions are reflected there, all good. Okay. moving on from antitrust. This is, again, state of the legal union address. There's lots, I'm covering a lot of different things, high levels, and giving you the resources so that you know where to go to get more information. What else is happening? We've got the Department of Labor rule that has narrowed the scope of how independent contractor classifications are done. So that went live on Monday, actually. What does this mean? So many, and what does it matter for the real estate industry? Well, it matters because the Department of Labor, as you know, is the one that makes all these different rules around labor and employment relations. Okay, fine. So one of those things is independent contractors. As you know, if you are a worker, you're an independent contractor or you are an employee typically, right? And there are different standards that you look at. If you misapply the standard and you misclassify someone as an independent contractor when they should have been an employee, there are pretty severe damages that you could face from the government, private lawsuits. Really important to make sure that you are properly classifying workers. So what's new here? The rule that was in place has been rescinded and it reinstates a previous standard. So if you've been around long enough, you know, it's not that big of a change, but it is. We're going back to a previous standard within this previous standard, which is now the new standard and the current standard. It requires that we look at a totality of the circumstances analysis of all the economic factors of the worker, right? So it is more worker friendly because the last standard was like, look, you really look at the opportunity for gain or loss, and that was one of the two factors that got more weight, and that really, you know, solidified that real estate agents are generally independent contractors, right? Not to say they can't be employees, but typically the way the businesses are structured, often the way businesses are structured, that's what they do. Again, unilateral and independent business decision. They can make their own decisions about how brokerages can make decisions about how they want to structure their workers. Be really mindful that if you have questions about this, talk to an attorney, call the Florida Realtors Legal Hotline, because you want to make sure that your independent contractor agreements reflect the current law and comply with the new old rule. Next, the Corporate Transparency Act. You all have probably heard about this quite a bit. The Corporate Transparency Act is a federal law. This is not just Florida. So this is a federal law and it applies to the majority of all businesses. So what is it? It requires beneficial owners, in air quotes, of corporations and LLCs to disclose and file certain information. So that is beneficial owners are people with an ownership percentage or substantial control of the business. So think CFOs, CEOs, boards, business owners, right? And why was this law passed? Well, the rationale given is they want to crack down on crime. They want to make sure they're tracking financial crimes, all of that, you know, all of those things. It is a very overreaching law. I mean, it requires beneficial owners to file really, quite invasive reports about what is going on with their business. And it's also problematic because if you don't file, there are penalties of $500 a day up to $10,000 and jail time up to 2 years. I mean, it is really, in my opinion, a very overreaching, really, really intrusive law. So what do? The law was effective January 1st, 2024, and you have until December 31st of this year to file that report. All right. If you're a new company, the exception to that is if you're a new company formed after the first of the year, you've got 90 days to file. Now, if you're one of these companies that was already in existence before the first of the year, you have until December 31st of this year to file. We are currently recommending, as of today, we are in March, we are recommending that you hang off just a little bit as long as you file on time, because there is a ton of litigation challenging this law. There was one court that invalidated the law, but the way the decision was written was that it applies to the sort of hold or stay on having to file these reports only applies to the plaintiffs in that case. And so you probably are not captured in that lawsuit. Most people are not captured in that lawsuit. It was an association. So the law is making its way through the courts. The challenges to the law are making their way through the courts. There are more cases pending. So we are waiting to see what happens with all of those, and waiting until the last minute really to file, because we want to make sure that not filing unnecessarily. So it's, not fun to be in this waiting game, but we've got the rest of the year to wait for it. And we are also at the association hosting webinars specific to this, so stay tuned for those. Now, there are also exceptions to this law, but most of our members are not going to meet those exceptions. The Corporate Transparency Act exempted companies with more than 20 employees. They exempted nonprofits. They exempted organizations like banks and all of these, because big companies, I guess, are not committing fraud and money laundering. The focus was small businesses, which is also, really problematic, and it definitely gives rise to other legal challenges. So stay tuned. The end of the story is that this is still pending with the courts. We will see what happens next. And we're getting questions in the chat about if you have an S Corp or an LLC, does this apply? Yes, it does. And what are we supposed to file, and where do we file? So it's a report, and it's at the bottom of the screen here. There's a website, www.fincen.gov/BOI. It's on the screen. You will have these slides after today. And I'm posting the link to the slides in the chat now for those of you who are on with us. The forms are there. The information is all on that website that I just posted. But again, and you are free to file now. I don't want anybody to think that they can't file now, but just letting you know that, prevailing advice right now is sort of wait and see what happens, since it is very invasive. All right, next, SB 264. All right, this is a law that was passed last year. Well, this was a bill that turned into law. It was SB 264. And we keep calling it by its bill name because that's what everybody knew it by. So we've sort of just stuck with it. And this is about the interests of foreign countries. We are not going to go in super deep detail on this because it is a very long, complicated law. The summary of the rule, there are QR codes up on the screen to the links. So the first link is the summary of SB 264, rulemaking and litigation updates. Really important to get that link. It's on our legal updates page. Spoiler alert, www.miamirealtors.com/legal updates. It wasn't just the law, right? So you have the new law that's in place, and now you have all of these rules that the different state agencies who are in charge of implementing the rule had to make to implement the law, because the law was a little vague on quite a few points. And so you are going to make sure that you take a look at that legal update, because it goes into detail on the status of the rules, on the status of the law, where we stand on everything. The second chart is a flow chart that Florida Realtors put together last year, and a memo with important definitions that relate to the law. Everything in SB 264 is defined somehow, and defined legally, right? So don't just assume that, like a person is a human, right? And don't think that domicile has a specific meaning. All of these words are laden with very specific definitions. And then if you are very curious and you can't sleep at night and you really want to read the full text of the law, I have that link there too for your reading pleasure. Big picture, look, the law is in place, and there was, if you were part of webinars that we've done in the past, there is litigation pending in Florida court that is challenging the Florida federal court, that is challenging the constitutionality of the law. There are very serious fair housing problems and civil rights issues tied to this law, as all of you, our members, have flagged for us, and as we have discussed in the past. And the lawsuit addresses those. Not only do they address those, the law is, the plaintiffs argue that the law is preempted by all these other federal laws that really do the same thing, but in a non-discriminatory way, and does not punish our members with criminal liability if there is an alleged violation of the law. So that case, what is going on with that case? Well, in that case, last summer, they filed what's called a motion for injunctive relief. They wanted the court to put a pause on the enforcement of this law pending the outcome of the lawsuit. The court said no. They said, nope, we're not doing it. The plaintiffs appealed. They went to the 11th Circuit, they appealed, and the appellate court agreed with the plaintiffs. They very clearly agreed with the plaintiffs that this law is very problematic, which is great news, except that it doesn't apply to you or your customers. If you were not a plaintiff in that case, the injunction does not apply to you. So for you all, of course, unless if the plaintiffs are here with us today, then great. But it applies to you, but the rest of Florida, it does not apply to them. So this law is currently in effect. Stay tuned. We will keep you posted with any other updates that come through on that. And and I do see a question in the chat that we got earlier. Can we provide the conditions to pass the domicile test? So I cannot, because one, the definition is still a little vague in how domicile was later defined, and that's in the rules in that first link that is on the screen. And I will say this: any deal that might trigger SB 264, and every deal does trigger SB 264 at this point, because buyers have to sign affidavits, as you know, that they are not prohibited from buying property based on this law. So if you have a deal where SB 264 might be implicated, and when I say implicated, I mean the buyer might not be able to purchase property under SB 264, you need to lawyer up. Both the seller and the buyer should get legal advice, because it is going to depend on a lot of different things. It's going to depend on the human buying the property. And it's going to depend if there's a human tied to a company who's buying the property. It could also trigger SB 264, depending on the ownership structure. It's going to depend on the location of the property. So as you know, there are restrictions on proximity to agricultural lands, critical infrastructure, military infrastructure, military installations. So you are going to want to get specific legal advice about that specific transaction, because again, it's going to depend on the person or company buying the property, where it's located, and it's also going to depend on the nationality and domicile, or nationalities as it might be, since we are South Florida. We have many, many buyers who hold multiple citizenships in different countries. And you're going to want to know where they are domiciled. And domicile gets tricky because of the way it has been defined. So I know that does not answer your question to the person who put that in the chat, but it is a really, really sticky question. And I do not want to give advice that would run afoul. I don't have all the facts. I do not want to opine on how that would apply. So next issue that we have is DMCA. So this has been resurfacing again in what we've been seeing out in the real estate world. The DMCA. If I am speaking to you in a language that is like, what is she talking about right now? DMCA, then you need to pay attention, because this is for you. This is a get out of jail free card in real estate, or if you're operating any kind of internet business. It is free. It's free. It is a free defense available to you in copyright lawsuits. And who does not want that? And so why are we seeing this in the, the real estate industry? Well, here's what's happening. Somebody uses pictures that they found on the internet, puts them into a listing, right? Uploads it to the MLS. And then of course the MLS syndicates those listings to the world. Well, the person who actually owned that picture sees the MLS listing and says, hey, that was my picture, right? So they might see that listing on another person's website or an agent's website who didn't put the listing into the MLS. That other agent who has the IDX feed is subject to a copyright lawsuit, because they are displaying a picture that is copyrighted that the person doesn't have the right to display. And if you're thinking, oh my gosh, that is so not fair. If I have an IDX feed and all these pictures are coming through and I didn't put them there for these listings, how could I be liable? Well, copyright law. And copyright law also recognizes that that's not very fair. So they've given individuals and companies DMCA protections. It's called the Digital Millennium Copyright Act. And you have to take some really simple steps to get those protections, and you are pretty much good. How does that play out? So one, you can't have actual knowledge of the content, right? And if you have an IDX feed, there is no way you have actual knowledge of the hundreds of thousands of listings that come through the MLS. Fine. You have to be unaware of the facts and circumstances from which the infringement is apparent. Yeah, same thing. There are hundreds of thousands of listings. Next, you are not getting any financial benefit attributable to the infringing activity. Generally, that's going to be the case. You need to act quickly to remove it. So if you see something and you know somebody reaches out to you, or you yourself know that it's a problem, then you need to report it to the MLS. You need to report it to MLS@miamire.com. And we have a whole takedown process that we go through to figure out if the photo is copyrighted and it's being used inappropriately, all of that. But once you've done that, you've got yourself a nice paper trail that you're doing what you need to do to fix the issue. Then you need to provide a way for somebody to contact you to take down that photo that is that has, or the whatever infringing content it might be. And how do you do this? Well, there's some magic language that you need to put on your website, and you do not need to invent it yourself. We have it on miamirealtors.com/legal updates for you to get and copy and paste onto your website. It's really, really easy to copy and paste it right on there. And it's basically like, hey, if you've got a problem with something on our website, here's how to contact us. All right. And then we'll deal with it. You also have to register that contact person with the US Copyright Office. They're called the designated agent. And that's just a fancy way of saying they're the person who gets notice if there is a problem. And it's super easy. It's free. Do it today, because it will save you a world of trouble later. All right. Now I'm going to take a breath and check the chat box to see if you all have any questions. All right, I'm seeing a question about the Corporate Transparency Act. Does it apply for a statutory entity or any entity that has an EIN? So I'm not sure what the statutory entity means, but if you are a corporation, a company, an LLC, those typically have EINs, but not always. So you are going to want to visit the, non-statutory trust. So the trust, to be honest, I am not sure. If there is a trust, I don't know. And that is something that you are going to want to attend, but I'm going to look it up as soon as we are done today. For trust, I don't know. Where is my Corporate Transparency Act? Here it is. But you should go to fincen.gov/BOI to take a look. That is where the guidance exists for if you need to file and how to file. And again, typically companies, corporations, LLCs have to file. And I know statutory trusts, like trusts, are not statutory entities. So you don't go to Sunbiz to file. They're not companies. They're not LLCs. They're none of those. And so check that website. Attend our webinars. We are having attorneys who specialize in this show up on these webinars to answer questions and to teach about it. I'm actually going to text them or email them after we're done today to see. And so make sure that you go to this website, check it out. You might meet one of the exemptions. You might not, but you are going to want to get advice either way. If you're unsure, you're going to want to get advice one way or the other. All right. Any other questions? Don't all email me after we're done. Now is the time. Anything else? Anything else? All right. Seeing no additional questions, I'll put one last chat with the link to the slides today. Thank you all for attending. Really appreciate you. Appreciate our Miami Realtors team a ton. And yeah, thank you again for being Miami members. Have a great day. Kevin, anything else?
Amazing job as always.
Bye, y'all.
Give up on my way.